and a very, very warm welcome to all of you who have joined us from around the world in different time periods. Some of us I know are very late in the night, and some of us are very early in the morning. But we have a wonderful lineup of people, panelists today from all different parts of the world in celebration of the Routledge Handbook of Law and Society. This is a very exciting event, incorporating scholars from many, many disciplines, many different trainings and backgrounds from around the world who have participated in this extremely exciting volume. It's over 60 people. Some of the contributions were co-authored and so on, but it is a very expansive and interesting edited volume that I've been very proud to participate in as a co-editor. So I'm Eve Darian-Smith, and along with Mariana Valverde, Kamari Clark, and Prabha Katswaran, we were the 4 editors of this volume, which you will hear a little bit more both about the volume and its inception and its innovative start, as well as from 4 of the people who've contributed to the volume itself. So again, welcome. I'm going to give you a little bit of sense of the format today, since I'm trying to keep us moving along in a timely fashion. I will first introduce Penny Andrews and Mariana Valverde, who will give a few opening comments about the volume. And then I will introduce our 4 speakers. The 4 speakers are going to be talking both about their contributions, but also I'm reflecting more generally on a sort of framing question that I've put in the chat, and that's meant to be a sort of guide for the conversation today. And this framing question is, what does law and society scholarship have to say about justice and contemporary inequality, and what is it not saying? And at the end of the 4 panelists, who will speak for a few minutes each, we would love people to put their comments and reflections perhaps in the chat. And Mariana and I will call on a few people who may want to say something around this framing question, sort of in a more general opening up of the conversation to be a more inclusive conversation. And then finally, of course, I want to raise a glass at the end of our session today, and in celebration of everyone's hard work and the fact that we're here together celebrating this wonderful volume. But before I hand it over to Penny Andrews, I just wanted to give a thanks, a call out to those who have made this event and the volume itself happen. And I first want, of course, thank Steve and Greg, Steve Boucher from the Law and Society Association Executive Director, and Greg for the technology behind the scenes in pulling together this platform through LSA's capacities to make this happen, which is extremely, we're all extremely grateful for everything they've done to make this work. Then I want to give a big thanks to Colin Perrin, who's the commissioning editor at Routledge, who originated the idea or had the original inception for the idea of the volume. I want to thank all the 60+ people who have contributed in the essays and their extreme commitment to making this all happen. A big, huge thanks to Ana Ballesteros Pena, who's been the assistant helping Mariana in particular at the University of Toronto, for her extraordinary efforts in editing and pulling all these contributions together. A very, very big thank you to the co-editors, Kamari and Mariana and Prabha, and a very special big thank you to Mariana, who as the main co-editor of the volume really made this happen. Without her, it would not have come together in such a timely and elegant fashion, with a beautiful cover and all the contributions being carefully, meticulously edited. So thank you, Mariana. You really did pull this together on behalf of all of us. So without further ado, let me introduce Penny Andrews, who I don't think I have to really give a huge introduction. She, of course, is the current president of the Law and Society Association. And I think many of you on this Zoom have had direct communications with her on a variety of fronts over many years. But she's currently at the New York University Law School, which she joined in 2019, teaching comparative and international law, serving also as the co-director of the law school's Racial Justice Project, which focuses on international and South African issues in particular. Prior to her joining New York University, She served as Dean of the Albany Law School and Dean of the University of Cape Town Faculty of Law. So thank you, Penny, for joining us this morning and adding this to your long list of exciting commitments as we run up to the annual Law and Society meeting shortly in a month or so. So I know you're a very busy person. At this point, I'll also introduce Mariana Valverde, who also, I think many of you on this Zoom and in the Law and Society world generally have had direct communications with over many years. Mariana is a professor at the Center for Criminology and Social Legal Studies at the University of Toronto. She served as director of the center for many years and was one of the founders of the Sexual Diversity Studies program there. She's been a very big leader in social legal scholarship in Canada and of course around the world, and has received many recognitions from the Law and Society Association over the years, including the Henry Calvin Jr. Award in 2016, and also being awarded for 2 different books over the years, the Herbert Jacobs Book Prize. So both people, Penny and Mariana, are extraordinarily big leaders in social legal scholarship, and it's wonderful for you to both be here to begin the conversation around this volume. So I'll pass it over to Penny, who'll say a few words, and then Mariana, who will follow her.
Thank you, Eve. Just a correction, I'm at New York Law School, not New York University School of Law. I'm so thrilled that the Law and Society Association is co-sponsoring the launch of the Routledge Handbook of Law and Society. But before we start, I also want to add my thanks to Steve Boucher and his team at the University of Massachusetts and the LSA office, and especially Gregory Barlow for the logistics, the technology, and so on. So in the wake of a rather challenging period for many, including law and society scholars, this volume is a welcome and refreshing, and I dare say an inspiring addition to the body of law and society scholarship. There is much to say about this incredibly rich and comprehensive volume. And so my remarks, because I only have a few minutes, are a mere curtain raiser. The editors, who are also authors, are leaders in the field and impressive torchbearers for law and society scholarship. Starting with Mariana Valverde, who is an award-winning scholar in the field of law and sociology. In fact, I was thinking as Eve, as you were introducing Mariana, if LSA was royalty, then Mariana would be on the Dean's honors list. We also have Kamari Maxine Clark, a noted scholar in the field of diasporic and transnational studies. And of course, Eve Darian Smith, who has made her mark in international and global studies and is also, I'm very pleased to say, the incoming secretary of the Law and Society Association, as well as Prabha Koteswaran, a thoughtful scholar of feminism. Now, the editors to the volume have brought together an impressive array of engaged and thoughtful scholars, experienced as well as emerging ones, and that traverse a global and interdisciplinary field. In fact, the list of contributors reads like a who's who of sociolegal scholars, and they offer an intellectual smorgasbord of topics that cover the range of human and non-human concerns, including climate justice, food security, natural resource challenges, reproductive justice, the world of finance, and artificial intelligence. The strengths of this book are many, but especially because of the perspectives of the notable contributors, as well as the range of topics covered. In addition, the volume, committed as it is to the broader project of social justice and the eradication of inequalities, attempts to bridge the divide between theory and possibility by demonstrating how the seeds of conceptual tools are germinated in concrete and real-world situations. By interlinking and connecting theory and possibility, the space is created for some discrete and incremental advancement in the realms of advocacy, policy, and law. So as I applaud the editors and the contributors, I leave you in the audience with two messages. First, either you go and buy the book or you get your library to order one immediately. And second, seriously consider the volume either as a required or recommended text. Thank you.
Thank you very much, Penny, for those words. And Mariana, would you like to join us now?
Sure. Okay, so thank you very much, Penny, for those very generous words of introduction. And thank you for mentioning at the end that the book should be considered as a teaching resource. One of the reasons we wanted to commission the pieces rather than do an anthology of previously published stuff, which would have been easier. But one of the reasons we wanted to commission pieces was that I think many of us find that in our teaching, sometimes we end up using published scholarly articles that are a bit over the heads of the students. And so we really worked hard to ensure that the chapters were self-contained and did not use jargon so that they can be assigned to introductory students, whether in law schools or whether in social science departments or other contexts. So thank you for that. And Eve already did the thank yous that I was going to do, but I'll just reiterate two. One is to Ana Ballesteros, who rescued me in the final stages of this project. If you're ever going to do a handbook like this, I recommend that you have serious administrative support. And because she came in towards the end of the project, her name is not mentioned in the introduction. She may not get formal credit for it. So I wanted to mention her now. And also Colin Perrin, who, even if you don't know him, you will for sure have already read some of the books published by Routledge that he has commissioned. And so he's one of these eminence grise of law and society because of having commissioned a lot of important works in critical legal studies. Okay, so just a word about, not so much about the book, but how it appears now. It struck me when I was leafing through it, when it arrived in my mailbox, that that the book is actually even more timely than what we thought back in 2018 and 19 when we were starting this. And it's even more timely because I think during the pandemic, there's been a series of important and serious reckonings. There's of course been the racial reckoning that maybe was most visible in the US, but certainly has been felt around the globe. And there's also a gender reckoning, although maybe that's less visible, and maybe it'll be after the pandemic is over that people will finally say, oh, gee, millions of women have dropped out of the labor force. Isn't that too bad? And I think the gender reckoning will mean that the long-standing Whig history narrative about women rising to socioeconomic equality, just, you know, sort of like a plant that is growing. I mean, that narrative, I think, will seriously be challenged if it hasn't been challenged already. And also, in many places, there's been a class reckoning, which I think has been a long time coming. But where I live, in Toronto, for example, a lot of white middle-class people have suddenly seen what anybody in Black Lives Matter could have told them a year ago, which is that the biopolitical burden of COVID is very unevenly distributed. And so that is bound to keep going. And we see, for instance, in Ontario, where I live, that the Conservative government has resisted tooth and nail the calls for providing sick paid days for workers who don't, who are not unionized and otherwise wouldn't have them. And finally, there's a sort of environmental reckoning that has been long in coming, but in some ways will get more attention in the post-pandemic period. So in that sense, as I said, the book seems even more timely than it did at the beginning, and I'm really hoping that it does get used as a teaching resource and also as a resource for what we used to call popular education, sort of back in the 80s or something. Adult education. I mean, all the entries are quite readable for activist groups, for instance, and they may not have the ability to buy the book, but the ebook is accessible, and some of the e-chapters can be made accessible too. So I hope that this goes beyond the academy, because in the end, the book is much more about justice than about law. So anyway, I'll leave it there, and now we can hear from authors.
Fantastic. Thank you, both Penny and Mariana, for those opening words about the volume, situating it in a bigger sort of framework of contemporary social justice issues and its contributions both to teaching in law school, but also to classes in social legal theory, in sociology or anthropology, and so on. So it has very pleased it has a wider application beyond a strict sort of legal framing. I'm now going to turn to our four panelists, and I'm going to introduce them all together, just giving a few words about each. I'm going to ask at the end that people don't necessarily direct their questions or their thoughts directly to each of the panelists, because you can all contact them independently in a moment of trying to be inclusive and have a bigger conversation. Just want to remind us that as you join or you want to join in the conversation at the end of their contributions here, please think about the framing question that I put at the beginning of chat, and any additional thoughts you may have building off their contributions and their conversations into thinking more inclusively about social justice. So the first person that we will hear from is Amy Cohen, and her entry into the handbook is on agriculture, law, and the state. She's at the University of New South Wales, University in Sydney, Australia, which is a fantastic university and has a fantastic law school. And her two areas of legal scholarship are very much around mediation and conflict resolution. She's interested in organizations building alternatives to the criminal legal system, as well as law and economic development, including the law and political economy of agriculture and food. After the law school, she taught at the Kathmandu School of Law in Nepal. As a Fulbright scholar, she clerked on the US Court of Appeals, and she worked on community development initiatives in Ghana, Nepal, and Thailand. So she brings an extraordinary breadth of experience from places around the world to the conversation. Next, we'll hear from Injin Izin. His contribution or his essay is on citizenship. And Injin is at the School of Politics and International Relations at Queen Mary University of London, and also he has an appointment at the University of London Institute in Paris. So he is also a person that spans different communities, social legal communities, and worldviews. He's trained as a political and historical sociologist, focusing on doing international politics. And by that, he's looking very much at the ways in which people constitute themselves as actors or subjects of international politics, and how they may resist colonial, imperial, and national practices through a range of activities that include performances, movements, and particular struggles and social movements around those struggles. He's very interested in how people constitute themselves as international citizens, and it's not surprising that he's the chief editor of the journal Citizenship Studies, and editor of a very exciting book series called Frontiers of the Political. So again, a great contribution in terms of what he brings to the conversation. Our third panelist is Brenda year, and her essay was on migration. Brenda is a professor of social sciences in the Department of Geography, as well as director of the Humanities and Social Science Research Office at the National University of Singapore. Brenda is unfortunately joining us from very late in the evening, so thank you so much for your patience on that front. Brenda's work and research interests include the politics of space in colonial and post-colonial cities, and she also has a considerable experience working on a wide range of migration research in Asia, including key themes such as cosmopolitanism, highly skilled migrations of particular communities, gender, social reproduction, and care migration, which is a fascinating area that's often overlooked. And she also, of course, works on bigger framing questions of national identity and citizenship issues and the cultural politics that inform those citizenship issues. So, and finally, and this is a wonderful sort of dimension of Brenda's work, it's about globalizing universities and international student mobilities, which of course, in the current moment that we're in, everyone's very focused on in terms of how one encourages international students to continue their studies. And finally, but not least, is Sarah Hunt, and her essay in the handbook is on settler colonialism. Sarah is a professor and Canada Research Chair in Indigenous Political Ecology in the Department of Environmental Studies at the University of Victoria in Canada. Sarah's writings have been published in a number of scholarly journals, including Geography Compass, Atlantis, and Cultural Geographies, as well as in a variety of research reports and popular media outlets. So Sarah is very much a public intellectual in my view. Building on her previous work on justice, violence, gender, and self-determination, her current research focuses on Indigenous peoples' understandings of justice across the nested scales of lands, waters, homes, and bodies via engagement of coastal peoples, embodied knowledge, and land-based cultural practices. So you can see we've got 4 panelists who are from a variety of different trainings and positions and perspectives and social legal communities here to reflect upon both their essay in the Routledge Handbook, but also on the bigger framing question we have. So we'll do it, we'll have you speak in the order that I introduced you, and please take it away, Amy.
All right. Thank you, Eve, so much for such a generous introduction, and to all the co-editors for including me in this extraordinary volume. So I want to start by saying that Eve recently, I think, very aptly described law and society scholarship as about sustaining, quote, the intellectual capacity to imagine alternative understandings of law, justice, or common good, end quote, in a world increasingly dominated by a political and economic elite. And to engage with our question, I'm going to diverge a bit from my chapter on agriculture and propose that the socio-legal literature on disputing is especially relevant today for scholars attempting to advance counter-hegemonic articulations of justice, both within and beyond the state. So the socio-legal study of disputing was an early approach to illuminating the field's raison d'etre, namely to analyze the mutual constitution of law and society. It was a particularly useful approach because it requires analysts to refuse to approach law or society as conceptual abstractions. When scholars begin with micro-level conflict, they must engage with specific concrete needs that people articulate as they work out practices of interdependence and justice across value difference, rather than engage with abstract positions about, say, the state or capital. So just to say a little bit more, sociolegal studies of disputing emerged in the 70s and 80s. Founding law and society scholars asked how extra-state dispute processes, such as mediation, were functioning as part of state governance and potentially also as a disruptive practice that could challenge the dominant order. So now this double theme of dominance and resistance is, of course, a classic law and society theme, but I think it's telling that early scholars developed this perspective in part by studying disputing. For example, Carol Greenhouse described mediation as something of a residual category, one that analysts sometimes define against state adjudication and other times define against self-help and violence. For her, mediation functioned as a kind of vector, as a practice that points to and is co-constitutive with the social order beyond it. Or to put this point a bit bluntly, one key insight I take from this early literature is how extra-state dispute processing can function as a practice where people on the ground point to gaps, to how the dominant order is failing to provide the forms of justice or safety, relationality, security, democracy that they are seeking. So I have an early project with Matt Canfield, one of my handbook co-authors, and Bronwyn Morgan, where we're examining how social movements are creating their own relational forms of negotiation, disputing, and self-governance across diverse areas, such as commons-based social enterprise, food sovereignty, and prison abolition. And I'll elaborate on each example just a tiny bit. So commons-based social enterprises aim to institutionalize principles of economic democracy. They may use non-market mechanisms, such as democratic deliberation, to determine how to control enterprise surplus and how to allocate inputs, such as compensating labor, even as they may use market mechanisms to distribute the goods they produce. They may also create novel accounting practices to track invisible care work and link these to internal income flows within the enterprise. In practice, however, these deliberative and novel calculative processes may entail intense conflicts, not least because negotiators can't resolve disagreements simply by referencing how to maximize profit. Hence, enterprises building post-capitalist forms of production are also building post-capitalist forms of dispute resolution. Like commons-based enterprises, movements for food sovereignty use deliberative democratic processes to determine how food should be produced and provisioned. In claiming sovereignty, actors seek control over natural resources, but they also seek to reconstruct sovereignty as a relational practice rooted in agroecological systems and collective self-governance. To that end, food sovereignty movements are building new forms of governance and dispute resolution, both within their own movement and through their participation in national and transnational institutions. And finally, movements of people organizing for prison and police abolition wish to take back control over responding to incidences of harm, conflict, and violence as they organize to hold states accountable for the harms they perpetrated against BIPOC people and others. Facilitators convene mediative interventions that ask how people who have caused harm can meet the concrete needs that survivors articulate, including needs for reparations, safety, accountability, separation. And in different national contexts, questions of reclaiming control over conflict and harm among marginalized and mass incarcerated peoples are linked in different ways to questions of sovereignty, jurisdiction, property, and indigeneity. So in each case, a sociolegal perspective uses disputing and conflict intervention to understand how people confront clashes among legal and social orders and negotiate the boundaries between them. It offers one approach to understanding how people, quote, come to terms with and often resist the penetration of official legal norms as they construct their own local universe of legal values and behaviors, to quote Susan Silby and Austin Surratt in their 1987 Critical Traditions in Law and Society research. Silby and Surratt then suggested that this legal pluralist perspective will produce, quote, instances that both confirm and contradict the dominant discourse, and that will require us to reimagine the discourse in a different way, end quote. That is, they suggested that through studying legal pluralism, analysts will produce resources to retool elite understandings of society, law, and economy. What sociolegal scholarship perhaps says less about, however, and I'll conclude here, is the substance and trajectory of collective efforts to retool society, law, and economy. Sociolegal scholarship teaches us how to move beyond state-focused understandings of law, but perhaps it offers fewer tools to move beyond state-focused understandings of economy, where capitalism is often positioned as something of a monolith. Just like sociolegal scholars have done for law, feminist community economy scholars such as J.K. Gibson Graham and their colleagues have challenged the idea that the economy exists apart from everyday efforts, decisions, practices, and interactions. they produced an extensive body of work that describes diverse, small-scale post-capitalist experiments in business, markets, and property that are already operating on the ground and often from within larger capitalist systems. This work offers an approach to studying economic pluralism, which sociolegal scholars can in turn use to complement and enrich projects of legal pluralism. For example, Bronwyn Morgan and Declan Kutch recently used this diverse economies research to articulate what they call diverse legalities. Through analyzing a wide range of disparate economic practices, they attempt to articulate plural legalities that, quote, temper law's tendency to consolidate capitalist practices, end quote, and that provoke us to imagine law itself as a kind of commons. So in my new project with Bronwyn and Matt, we're attempting to bring the sociolegal study of disputing to diverse economies projects to see how problems within these projects get framed, managed, and reconstituted, combining and multiplying the field sites and methods we have to articulate diverse possibilities against elite understandings of justice and a common good. Thank you.
Thank you very much. We'll now turn to Injin.
Thanks very much, Eve, for both the introduction as well as just drawing my attention to my order here. And thanks very much also for inviting me to participate in this event as well as in the volume. It's always a great pleasure to receive a book as a full. And when I got back home, just recently found the book in the mail and opening and seeing 52 chapters and all addressing really significant issues of our times. I felt quite proud and also quite humbled by the project itself. The editors, Mariana, Kamari, Eve, and Prabha set out a challenge in the introduction of the volume. And they say that the leading edge sociolegal scholarship today must take seriously the complex and overlapping assemblages of law and authority that inform our world, a world that holds multiple incompatible legal systems and a variety of incompatible views about what laws for and who has the authority to proclaim the law. That's really a significant opening, setting in context the challenge of the concepts that we work with and how do we rise to that challenge of thinking in these complex ways. As they indicate in the introduction as well, that for a long period of time, sociolegal studies or thinking about law work with the fiction that in each state, in each nation, there was a homogeneous set of laws. And in fact, there was no such complexity as they invite us to address. Now, one of the concepts that really fit to that challenge and is in need of expanding, re-articulating is citizenship. It has a long history. On one hand, it's a institution of a legal institution, but on the other hand, it contains in itself contradictory multiple lineages. And to separate those lineages and introduce the complexity is a difficult task. And I tried to address that in this entry by indicating at least two lineages of citizenship. On the one hand, historically, citizenship has been an institution of domination. What that means is that it's been used for domination of one group over other on the basis of race, gender, on the basis of ethnicity, religion, identifying a particular group as a citizen, an insider that has the virtues and capacities to practice citizenship, and those others who just don't have either the capacities or the ability to act themselves as citizens. So this institution of domination that institutes various practices such as revocation of citizenship, deportation, excommunication, historically, all sorts of practices with settler colonialism, imperialism, and colonialism instituted, separating people who have the right to have rights and people who do not have those rights. This is a significant lineage that has to be always mentioned and must be part of that challenge that the editors set out for social legal scholarship. And yet there's also another tradition, another lineage in citizenship, that for each of the marginalized, othered, dominated groups identified, categorized, and classified by the dominant ideologies, there have been, citizenship also have been an instrument of struggle. One could say that institution of emancipation. It has allowed various groups to overturn their dominated status, speak truth to power, as it were, and articulate various claims that identified why is it that any particular group or class, identity, a particular formation, assemblage, however we identify collectivities that are not part of the dominant established order, asking questions and struggling. So very strong element of citizenship is this tension and the struggle over, contestation over who has the right to be a citizen, to act as a citizen, to act as a person in law, and who doesn't. This is never ever settled. It is always a contestation. But bring out in the idea of citizenship that this contestation is one of the ways in which one could rise to the challenge that the editors set out. How does social legal scholarship today must take seriously the complex and overlapping assemblages of law and authority embedded in citizenship. But it also speaks to the prompting question of our discussion today in terms of what this way of social legal understanding of citizenship, how it can contribute to both raising questions about justice, but also inequality. In terms of inequality, obviously there is a way of reading citizenship, how it institutes inequality in citizenship laws. We know very many examples of not only excluded, but differentially constituted groups that don't have access to citizenship rights, or even when they do have access to citizenship rights, they can be excluded from it, such as the case was Windrush scandal. So this is a strong element of citizenship as domination, and it speaks to that inequality and how citizenship has historically embedded and instituted inequality. But it also speaks to the issue of justice, that citizenship as a technology or institution of emancipation, it provides at least preliminary ways in which people can make claims. By making claims to have rights, to articulate differentiated rights, or why asking questions about the rights that they don't have, or rights that they must have, or rights that they have but they are losing. We could give many examples from, for example, in the last 30, 40 years, with the shrinking of the state across the global north, and the employment rights, labor rights being reclaimed, first lost and then reclaimed, and the struggles around that. But also the citizenship rights that did not exist, for example, for gay, lesbian, and equality rights in terms of sexuality, but as well as rethinking about Black Lives Matters and the ways in which how, particularly in the United States, but around the global north, racialization of citizenship instituted certain forms of inequalities, and how decolonizing or questioning that is the first step for rethinking about citizenship as justice. We can give many examples, but the sociolegal studies today really speaks to these fundamental questions of our times in the ways in which citizenship institutes itself, both as a mechanism and technology of domination and emancipation. And this is really the key point I wanted to make in the entry, rising to the challenge that's set out by the editors, that if we in fact think of citizenship as providing only one, but not the other, if we understand citizenship not a tension-filled space of contestation, we are then held back, again, constituting citizenship in quite static legal terms, which really is an illusion, as the editors say. So to actually question that illusion means to understand the tensions that citizenship brings, embodies, and how those tensions also give rise to struggles and contestations.
Thank you very much. That's very, very interesting. I'll now pass it over to Brenda.
Hello, hi everyone. Just to begin by thanking the handbook editors and organizers of this roundtable for the opportunity to participate. I, through experience, have very little trust in the internet, so I'm going to use slides to back up. So let me see whether I can, in a sense, share screen. Are the slides visible?
The slides are visible. Thank you. Yes, good.
That's great. Okay, so I'm actually not a law and society scholar, but hope my expertise on migration issues can offer a contribution. I know I'm not the only geographer around, so I'm in a sense heartened by that. I will start with a small preamble to set the context on nation building in Asia and the place of migrants, because I want to speak to the question that has been offered through the lens of international migration and citizenship from where I am in Asia. So first of all, the challenges that contemporary migration pose to meanings and practices of citizenship in Asia have to be understood in the context of the historical development of nation states in the region. So when large-scale labor migration in the region began in the 1970s, many Asian countries were still in the process of nation state building. So we see Southeast Asian sort of post-colonial nation states such as Singapore, Malaysia, Indonesia, that are building sort of their nation states from an already sort of existing plurality that's rooted in the diasporas of colonial times. There are also East Asian polities such as Japan and Korea that constructed a sense of nationhood based on idealized narratives of ethnic homogeneity. So there's a wide range, a wide variety of nation building projects in Asia. And in this context, the labor migration system that developed in Asia minimize challenges to the fragile imaginary of the nation state by rendering migrants as transient sojourners. In other words, migrants' place in host societies to sell their labor, but make no claims on the receiving nation state. Migration regimes as such that emerged in Asia were premised on keeping migration temporary. So apart from a privileged pathway for highly skilled migrants to gain residency and citizenship, the vast majority of migrants in Asia are temporary contract-based migrants. So I have 3 points to make, and then I'll follow that up with a brief discussion of where law and society scholarship can be invaluable in addressing some of the significant gaps. And my first point has to do with migrants' access to legal citizenship in the receiving states in Asia, and this is extremely limited. The nation state views citizenship rules as legal instruments of exclusion, the domination that we just heard about, that sharply separates citizens from non-citizens, those who are insiders from those who are deemed outsiders. This view that there's a one-to-one umbilical relationship between person and state that confers specific rights and responsibilities is something that is seldom challenged in policy discourses in Asia. For the vast majority of migrant workers, pathways to residency and citizenship are highly circumscribed, accompanying family members strictly prohibited, and the transience and disposability are also enforced through restrictions on length of stay, job immobility, and rotating door policies in general. Second, the vast majority of migrants, particularly the low-skilled and the low-waged, are very much at the margins of social citizenship in host societies. Migrant groups without formal citizenship status often depend on civil society groups to connect to the wider public and to mobilize resources to effect claims making. So migrant activist groups can and do play an important role in expanding migrant social rights. We see examples in Taiwan, for example, where there's advocacy for more inclusive modes of citizenship for migrants. And in Singapore, NGOs have been advocating on substantial issues such as a day off campaign for migrant domestic workers. As you see in this particular poster that advocates giving a day off to domestic workers. It says there that she's not just your maid. She has a name, Lita. She works for her family as well as yours. So third, home nation states are increasingly interested in diaspora-centered developments and open to extraterritorial citizenship. So we see here that discourses around exiting the home nation state in the last few decades have been taking on more positive kind of developmental value. And the key impetus for this kind of discursive shift in meaning can be traced to the advent of the migration and development nexus that dominated international development agendas from around the 1990s. This is based on the migrant as a celebrated agent of development, powered by the euphoria of remittance-dependent development. So an example here would be in the Philippines, where turning citizens into labor commodities for the global marketplace and institutionalizing this kind of approach is a major strategy to address domestic poverty and unemployment. And it will appear that remittances have proven to be a far more reliable source of income than official development aid, for example, or even foreign investments in sustaining the economy. So this has in some cases led to the extension of extraterritorial citizenship rights to immigrants and diasporic descendants, but usually not to temporary migrants. And this is in order to encourage transnational linkages and homeward bound investments in home countries. So finally, I just want to use my last kind of couple of minutes to turn to the question of gaps. So in the arena of migration, where are the gaps in law and society scholarship in building a pathway towards justice and social equality? First, it is crucial to address migrant precarity, especially in the case of temporary migrants, and more needs to be done in heeding the call for international and regional cooperation amongst both sending and receiving states to find new ways to effect what Gordon calls transnational labor citizenship that's characterized by the portability of benefits and services and enforcement of baseline labor rights across borders. Second, and this is despite the fact that COVID-19 pandemic has unleashed xenophobic kind of tendencies against migrants, some scholars of international migration law has been arguing that this is also an opportunity for civil society and activist movements to offer a potential site for building a politics of interdependence that is centered around this question of a universal baseline of rights for migrants. So as the global crisis does not respect international borders, the pandemic offers us, I think, a choice. We either hunker down to narrow-minded nationalism or temper absolutist views of sovereignty and citizenship in view of the fact that no one is safe unless everyone is safe. So it's high time that temporary migration regimes are built on a more sustainable and equitable basis. And for this to happen, there is, I think, an important role for law and society scholars to rethink the relationship between the nation state on the one hand and its migrants. So I think that's all I wanted to share for today. So thank you very much for your attention.
Thank you for a wonderful intervention there. Very, very interesting. We'll now turn to Sarah for our final panelist.
Hello, Gila Kasla. Thank you so much for having me as part of this panel today. I want to first thank the editors for inviting me to contribute to the book and to contribute to this launch and conversation today on the nature of law and society scholarship. As an Indigenous scholar whose work has long been situated within the everyday struggles of Indigenous people and communities to have our voices heard within discourses of law and justice, it's just really an honor to be included in this conversation. Much of my own scholarship has come out of really grappling with the extreme injustice, the conditions of life and death, of loss and grief, of marginality and inequity that continue to shape settler colonial societies and much of the world today. From within these spaces, my relations who are most, I think, feeling the weight of injustice bear down on them have been and are still seeking to have their voices heard in bringing understanding to the true nature and depth of kind of how law operates in our everyday lives. But also in creating new imaginaries of justice today and into the future. And this is, I think, where this book's framing questions offer a vital contribution to how we think about law and society today, and particularly how Indigenous people's struggles are positioned within those conversations. So I was really delighted to read in the opening chapter the ways that Indigenous people's struggles on the ground are positioned by the editors, framing the collection to raise important questions about, through our ongoing and kind of grounded struggles, looking at the ways that we assert our legal authority and also resist the various layers and interactions with colonial law that continue to seek to dispossess us, not only of our lands and waters, but also our families, our inherent rights within our own laws, and our very lives. And so asking questions about the meaning and scope of law, as well as whose laws we're talking about, the editors bring forward a set of questions that for me really get at the long-term struggles that we as Indigenous peoples have engaged with since the early days of colonization. Many of the contributions get at the everyday terrains of in this collection. Many of the contributions get at the everyday terrains of struggle of Indigenous peoples globally to seek and define justice for ourselves, not only in relation to the violence of the state, but also in relation to the legal realms that our ancestors have long expressed. And so to this end, I thought, what I would bring to this conversation today is to think about how Indigenous law, while some of the scholarship, and there's been a lot of really important work, I think, to look at the ways in which injustice kind of plays out in our lives through criminalization, through overrepresentation in the justice system, and looking at barriers to justice, looking at how we continue to not be able to find justice for Indigenous peoples and the harms against us. But on the other side, I think there is work that's being done to bring forward, how Indigenous laws themselves continue to be expressed, and how those legal realms, what relevance they have for how we answer those questions of whose law, what is law, and how we understand that. And so I want to next kind of reposition myself, I guess, not just as a scholar, but as an Indigenous person, and what my position within our laws kind of bring to these conversations. And so I'll say that my name is Sarah Hunt, but my name is also Tlali Tlila Ogwa. My grandparents on my dad's side are Kwagil from Tsahis, or what's now known as Fort Rupert, part of the Kwakwaka'wakw Nation. I'm also Zawadinuk through my grandmother, and Tlingit through what's now known as Alaska, through my great-grandmother, Ani Slaga. And in positioning myself in this way, bringing forward my name and my position within diverse nations, this is not just a way of bringing kind of my social standing, but also the various legal traditions in which I'm positioned and that I carry with me in my body, carry with me to this place where I'm situated here on Lekwungen territories. And there are sort of various legal imaginaries that come with me then as part of positioning myself in this way. Coastal peoples have refused the imposition of colonial legal imaginaries and legal systems since contact, insisting that we will continue to cultivate our laws within our lands and uphold obligations to our neighbors. And an example that I continue to go back to in my own work and thinking about kind of how this lives today is looking back to the early days of criminalizing our legal traditions. So you may know that for 80 years, the potlatch was banned in Canada, and that's the tradition, the legal tradition that I come from. And in 1886, Chief Awaksalagalis from my community taught to anthropologist Franz Boas about the criminalization of the potlatch. And he said, "We will dance when our laws command us to dance. We will feast when our hearts desire to feast. Do we ask the white man to do as the Indian does? No, we do not. Why then will you ask us to do as the white man does? It is a strict law that bids us to dance. It is a strict law that bids us to distribute our property among our friends and neighbors. It is a good law. Let the white man observe his laws and we will observe ours." And so in this quote from Awaksalagalis, I see really what stands out to me is the focus on the dance. And the dance is significant for us because it is in collectively enacted ceremonial spaces where legal, economic, social, and spiritual structures are upheld over time, and where we get our sense of ourselves, which extend in obligations to the world around us. So when I think about our laws and this question of what is law, whose laws, I think of ancestral, spiritual, and place-specific norms that situate our bodies in place through repetitive collective practice. So there is no law, as we think of with kind of state law from above, but only law as alive in the practices of our people expressed via our bodies in place. We couldn't simply write our laws down and implement them kind of separately. They have to be danced, embodied, and expressed relationally. And so in terms of kind of where the scholarship has to go, what gaps are there, what possibilities are there? I think we still have a ways to go in thinking about Indigenous legal subjectivity, not just within kind of realms of the state, but within the dance of our laws in place over time, in reimagining what is justice and what forms of justice are possible. And while there's been a growth of work in the area of Indigenous law, I'm most excited about scholarship which considers the ways Indigenous people actually experience and imagine justice from within our own legal paradigms. We've done a lot of work, as I said before, understanding barriers to justice or law as a site of injustice, but I think we're still forming strategies to reimagine justice from within this dance. And this work takes up, I think, the late Patricia Monteur's call to constitute forms of justice, which she said has at its center the family and our kinship relations. And for me, this means asking new kinds of questions with Indigenous people's experiential knowledge at the center. And for me, some of the work that I'm doing is trying to really look at new ways of asking these questions. So, for example, a lot of the work that's been done on Indigenous women, for example, here with missing and murdered women here in Canada, a lot of the work has looked at kind of the violence of law in ignoring the violence that we experience, and seeing how that is compounded through the kind of neglect of the system, as well as the overcriminalization at the same time. And just those many realms in which we experience injustice. But thinking instead, sometimes those questions about injustice can really close off possibilities for continuing to seek justice from within these other imaginaries and from within the dance that I talked about. So thinking about what is possible within Indigenous laws that Indigenous women carry, for example. What is made possible when we bring Indigenous peoples to the center of those imaginings? And so I think with this collection, we can see that the scholarship is increasingly I think capturing the more intimate and everyday ways that we experience not just injustice, but also assert our own definitions of justice through our engagements within these multiple forms of law across the many realms of our lives. So, really thinking about the nested scales of justice that we're concerned with. So there's much more to say, but I just want to thank you for inviting me to be part of the conversation, and I'm happy to have some discussion now. Gila Kasla.
Thank you very much, Sarah, for a very important, significant intervention there. I want to thank all our panelists for your contributions. I actually think we could all sit around and have a wonderful conversation that builds on a variety of elements across all of the speakers today and builds on, of course, all the entries in the handbook. But given the time, and I know that some people have to run, I think we might draw it to a close, but I also want to pick up on Sarah's evocative intervention around dance and end on a note of celebration and dance and joy and intimacy. And I have got two venues, two different time spans. I've got a glass of champagne and a cup of coffee. So whatever is your particular moment in time and preference, I do want us to all raise something to the editors, to the panelists, to all the essayists, and all the amount of work for this very important reimagining legalities, plural legalities in the current moment, and for surviving a very, very long year of lockdown. So thank you to everybody, and hopefully the conversations will continue between ourselves over social media and digital platforms. But celebration, yay, hello, thank you, goodbye. And wonderful, wonderful intervention. Okay.
Thank you, everybody.
Thank you. And we'll call it a day at this point. Thank you again, everybody.